Stephen Gerald Breyer is a retired American lawyer and jurist who served as an Associate Justice of the Supreme Court of the United States from 1994 until his retirement in 2022. He was nominated by President Bill Clinton, and replaced retiring Justice Harry Blackmun. Ketanji Brown Jackson, who was nominated by President Joe Biden, was his designated successor. Breyer was generally associated with the liberal wing of the court. He is now the Byrne Professor of Administrative Law and Process at Harvard Law School. Born in San Francisco, Breyer attended Stanford University, the University of Oxford as a Marshall Scholar, and graduated from Harvard Law School in 1964. After a clerkship with Associate Justice Arthur Goldberg in 1964-65, Breyer was a law professor and lecturer at Harvard Law School from 1967 until 1980. He specialized in administrative law, writing textbooks that remain in use today. He held other prominent positions before being nominated to the Supreme Court, including Special Assistant to the United States Assistant Attorney General for Antitrust and Assistant Special Prosecutor on the Watergate Special Prosecution Force in 1973. He also served on the First Circuit Court of Appeals from 1980 to 1994. In his 2005 book Active Liberty, Breyer made his first attempt to systematically communicate his views on legal theory, arguing that the judiciary should seek to resolve issues in a manner that encourages popular participation in governmental decisions. On January 27, 2022, Breyer and President Joe Biden announced Breyer's intention to retire from the Supreme Court. On February 25, 2022, Biden nominated Ketanji Brown Jackson, a judge on the U.S. Court of Appeals for the District of Columbia Circuit and one of Breyer's former law clerks, to succeed him. The Senate confirmed Jackson on April 7, 2022, by a vote of 53-47. Breyer remained on the Supreme Court until June 30, 2022. Breyer wrote majority opinions in landmark Supreme Court cases such as Monoy Area School District v. BL and Google v. Oracle, and notable dissents questioning the constitutionality of the death penalty in cases such as Glossip v. Gross. Early life and education. Breyer was born on August 15, 1938, in San Francisco, California, to Anne A. and Irving Gerald Breyer. Breyer's paternal great-grandfather emigrated from Romania to the United States, settling in Cleveland, Ohio, where Breyer's grandfather was born. Breyer was raised in a middle-class Jewish family. His father was a lawyer who served as legal counsel to the San Francisco Board of Education. Breyer and his younger brother Charles R. Breyer, who later became a federal district judge, were active in the Boy Scouts of America and achieved the Eagle Scout rank. Breyer attended Lowell High School, where he was a member of the Lowell Forensic Society and debated regularly in high school tournaments, including against future California Governor Jerry Brown and future Harvard Law School professor Lawrence Tribe. After graduating from high school in 1955, Breyer studied philosophy at Stanford University. He graduated in 1959 with a Bachelor of Arts degree with highest honors and membership in Phi Beta Kappa. Breyer was awarded a Marshall Scholarship, which he used to study philosophy, politics, and economics at Magdalen College, Oxford, receiving a first-class honors BA in 1961. He then returned to the United States to attend Harvard Law School, where he was an articles editor of the Harvard Law Review and graduated in 1964 with a Bachelor of Laws degree magna cum laude. Breyer spent 8 years in the United States Army Reserve, including 6 months on active duty in the Army Strategic Intelligence. He reached the rank of corporal and was honorably discharged in 1965. In 1967, Breyer married the Honourable Joanna Frieda Hare, a psychologist and member of the British aristocracy, younger daughter of John Hare, 1st Viscount Blakenham and granddaughter of Richard Hare, 4th Earl of Listowel. They have 3 adult children, Chloe, an Episcopal priest, Nell, and Michael. Legal career. After law school, Breyer served as a law clerk to Associate Justice Arthur Goldberg of the U.S. Supreme Court from 1964 to 1965, and served briefly as a fact-checker for the Warren Commission. He then spent 2 years in the U.S. Department of Justice's Antitrust Division as a special assistant to its Assistant Attorney General. In 1967, Breyer returned to Harvard Law School as an assistant professor. He taught at Harvard Law until 1980, and held a joint appointment at Harvard Kennedy School from 1977 to 1980. At Harvard, Breyer was known as a leading expert on administrative law. While there, he wrote 2 highly influential books on deregulation, Breaking the Vicious Circle, Toward Effective Risk Regulation and Regulation and Its Reform. In 1970, Breyer wrote The Uneasy Case for Copyright, one of the most widely cited skeptical examinations of copyright. Breyer was a visiting professor at the College of Law in Sydney, Australia, the University of Rome, and the Tulane University Law School. While teaching at Harvard, Breyer took several leaves of absence to serve in the U.S. government. He served as an assistant special prosecutor on the Watergate Special Prosecution Force in 1973. Breyer was a special counsel to the U.S. Senate Committee on the Judiciary from 1974 to 1975 and served as chief counsel of the committee from 1979 to 1980. He worked closely with the chairman of the committee, Senator Edward M. Kennedy, to pass the Airline Deregulation Act that closed the Civil Aeronautics Board. U.S. Court of Appeals. In the last days of President Jimmy Carter's administration, on November 13, 1980, after he had been defeated for re-election, Carter nominated Breyer to the First Circuit, to a new seat established by 92 Stat 1629, and the United States Senate confirmed him on December 9, 1980, by an 80-10 vote. He received his commission on December 10, 1980. From 1980 to 1994, Breyer was a judge on the U.S. Court of Appeals for the First Circuit. He was the court's chief judge from 1990 to 1994. One of his duties as chief judge was to oversee the design and construction of a new federal courthouse for Boston, beginning an avocational interest in architecture and the Pritzker Architecture Prize. Breyer served as a member of the Judicial Conference of the United States between 1990 and 1994 and the United States Sentencing Commission between 1985 and 1989. On the Sentencing Commission he played a key role in reforming federal criminal sentencing procedures, producing the Federal Sentencing Guidelines, which were formulated to increase uniformity in sentencing. Supreme Court. In 1993, President Bill Clinton considered him for the seat vacated by Byron White before ultimately appointing Ruth Bader Ginsburg. But after the retirement of Harry Blackmun, Clinton nominated Breyer as an Associate Justice of the Supreme Court on May 17, 1994. Breyer was confirmed by the Senate on July 29, 1994, by an 87-9 vote, and received his commission on August 3. In 2015, Breyer broke a federal law that bans judges from hearing cases when they or their spouses or minor children have a financial interest in a company involved. His wife sold about $33,000 worth of stock in Johnson Controls a day after Breyer participated in the oral argument. This brought him back into compliance and he joined the majority in ruling in favor of the interests of a Johnson Controls subsidiary which was party to FERC Electric Power Supply Association. From the start of his tenure through the end of the 2019 term, Breyer wrote a total of 520 opinions, not counting opinions relating to orders or in the shadow docket. Abortion. In 2000, Breyer wrote the majority opinion in Stenberg v. Carhart, which struck down a Nebraska law banning partial birth abortion. On June 29, 2020, he wrote the plurality opinion in June Medical Services v. Russo. The ruling struck down Louisiana's abortion law requiring any doctor who performed abortions to have admitting privileges at a hospital within 30 miles. Breyer reaffirmed the benefits and burdens test he had created in Whole Woman's Health v. Hellerstedt, which struck down a nearly identical abortion law in Texas. In 2022, he dissented in Dobbs v. Jackson Women's Health Organization, which overturned Roe v. Wade. Census. In Department of Commerce v. New York, Breyer was in the 5-4 majority that ruled that the Census Bureau had not followed proper procedure in its implementation of a citizenship question. He was also one of 4 justices who would have held the citizenship question unconstitutional in itself. In a mostly concurring opinion, he wrote, "Yet the decision was ill-considered in a number of critically important respects. The Secretary did not give adequate consideration to issues that should have been central to his judgment, such as the high likelihood of an undercount, the low likelihood that a question would yield more accurate citizenship data, and the apparent lack of any need for more accurate citizenship data to begin with. The Secretary's failures in considering those critical issues make his decision unreasonable." On December 18, 2020, Breyer was one of 3 dissenters in Trump v. New York. In a 20-page dissent, he argued that the court should not have sidestepped the case and should have ruled in favor of the challengers, who wanted the court to block the Trump administration's last-minute attempts to exclude undocumented immigrants from the census. The census ultimately did not exclude undocumented immigrants, due to a lack of time and the subsequent issuance of Executive Order 13,986. Copyright. In Eldred v. Ashcroft, decided on January 15, 2003, Breyer and Justice John Paul Stevens filed separate dissenting opinions. In his 28-page dissent, Breyer argued that the 20-year retroactive extension of existing copyright granted by the Copyright Term Extension Act amounted effectively to a grant of perpetual copyright that violated the Copyright Clause of the Constitution, read in light of the First Amendment. He argued that the extension would produce a period of protection worth more than 99.8% of protection in perpetuity and that few artists would be more inclined to produce work knowing that their great-grandchildren would receive royalties. He also wrote that the fair use defense came to no avail either, as it could not help those who wish to obtain from electronic databases material that is not there, e.g. teachers who can find from online no ideal material to be used in the class as it has been deleted. In 2012, he expressed a similar idea in his dissent in Golan v. Holder, which affirmed the constitutionality of the application of Section 514 of the Uruguay Round Agreements Act of 1994. In 2005, while joining in unanimous court in MGM Studios, Inc. v. Grokster, Limited against peer-to-peer file sharing companies Grokster and Stratmcast on the ground of inducement liability, Breyer wrote a concurrence that the companies would be protected under the Sony doctrine without evidence of inducement. In American Broadcasting Co., Inc. v. Aereo, Inc., decided on June 25, 2014, Breyer delivered the majority opinion, ruling that Aereo, allowing subscribers to view near-live streams of over-the-air television on Internet-connected devices, operated so overwhelmingly similar to the cable companies that it violated the right of public performance of the network's copyrighted work. In Google v. Oracle, decided on April 5, 2021, Breyer wrote the 38-page majority opinion, holding that Google's copying of 11,500 lines of Java declaring code constituted fair use because 3 of these packages were fundamental to being able to use the Java language at all. Breyer explained, by using the same declaring code for those packages, programmers using the Android platform can rely on the method calls that they are already familiar with to call up particular tasks, but Google's own implementing programs carry out those tasks. Without that copying, programmers would need to learn an entirely new system to call up the same tasks. Death penalty. In 2015, Breyer dissented in Glossip v. Gross, which held by a 5-4 vote that prisoners challenging their executions must provide a known and available execution method before challenging their method of execution. In a dissent joined by Ginsburg, Breyer questioned the constitutionality of the death penalty itself. He wrote, "For the reasons I have set forth in this opinion, I believe it highly likely that the death penalty violates the Eighth Amendment. At the very least, the court should call for full briefing on the basic question." In July 2020, Breyer reiterated this position, writing, "As I have previously written, the solution may be for this court to directly examine the question whether the death penalty violates the Constitution." Environment. In Friends of the Earth, Inc. v. Laidlaw Environmental Services, Inc., Breyer was in the 7-2 majority that held that people who use the North Tiger River for recreational purposes but could not do so due to pollution had standing to sue industrial polluters. On April 23, 2020, Breyer wrote the majority opinion in County of Maui v. Hawaii Wildlife Fund. The court ruled that the County of Maui must have a permit under the Clean Water Act in order to release groundwater pollution into the ocean. Although the ruling was less broad than the Ninth Circuit's ruling, environmentalist groups saw the ruling as a win and an affirmation of the Clean Water Act. On July 31, 2020, Breyer dissented when the Supreme Court, in a 5-4 decision, refused to lift a stay on the Ninth Circuit ruling that halted construction of the wall at the U.S. Mexico border. The Sierra Club argued that the wall would harm the environment unduly, including threatening wildlife and changing the flow of water in the Sonoran Desert. Breyer wrote, "The court's decision to let construction continue nevertheless, I fear, may operate, in effect, as a final judgment." Ginsburg, Sotomayor, and Kagan joined his dissent. On March 4, 2021, Breyer dissented in United States Fish and Wildlife Serv v. Sierra Club, Inc., joined only by Sotomayor. The case concerned the Sierra Club's request under the Freedom of Information Act for draft opinions concerning rules governing underwater structures that are used to cool industrial equipment. The Sierra Club argued that it had the right to access the documents. The majority opinion limits environmental groups' ability to obtain government documents under FOIA. Breyer wrote in his dissent, "Agency practice shows that the draft biological opinion, not the final biological opinion, is the document that informs the EPA of the service's conclusions about jeopardy and alternatives and triggers within the EPA the process of deciding what to do about those conclusions. If a final biological opinion is discoverable under FOIA, as all seem to agree it is, why would a draft biological opinion, embodying the same service conclusions, not be?" In Holly Frontier Cheyenne Refining v. Renewable Fuels Association, Breyer ruled for oil refineries, joining the majority opinion, which held that oil refineries struggling financially did not need a continuous exemption every year since 2011 in order to be granted an exemption from federal renewable fuels policy. Health care. Breyer generally voted to uphold the Affordable Care Act since its passage in 2010. He wrote the 7-2 majority opinion in California v. Texas, a decision on June 17, 2021, holding that Texas and other states lacked standing to sue against the Affordable Care Act's individual mandate. Breyer wrote, "It is consequently not surprising that the plaintiffs cannot point to cases that support them. To the contrary, our cases have consistently spoken of the need to assert an injury that is the result of a statute's actual or threatened enforcement, whether today or in the future." Partisan gerrymandering. On April 28, 2004, Breyer dissented in VF v. Ubalirator, in which the court held that partisan gerrymandering is a non-justiciable claim. Breyer wrote in his dissent, "Sometimes purely political gerrymandering will fail to advance any plausible democratic objective while simultaneously threatening serious democratic harm. And sometimes when that is so, courts can identify an equal protection violation and provide a remedy." In 2006, Breyer was in a 5-4 majority holding that District 23 of the 2003 Texas redistricting violated the Voting Rights Act due to vote dilution. Along with Justice John Paul Stevens, Breyer would also have ruled in favor of plaintiffs' claims that Texas's statewide plan was an unconstitutional partisan gerrymander. In June 2019, Breyer dissented in Ruscio v. Common Cause, in which the Supreme Court decided 5-4 that gerrymandering is a non-justiciable claim. Voting rights. Breyer wrote the majority opinion in Alabama Legislative Black Caucus v. Alabama, which ruled that racial gerrymandering claims must be looked at district by district, and struck down 4 of Alabama's state Senate districts as unconstitutional racial gerrymanders. Breyer joined Ginsburg's dissent in Shelby County v. Holder. A 5-4 majority ruled that Section 4 of the Voting Rights Act is unconstitutional. Breyer joined another dissent by Ginsburg in RNC v. DNC, which overturned a lower court's extension of a voting deadline in the Wisconsin primary elections. The lower court had extended the deadline so that people who had not yet received mail-in ballots by April 7 could vote by mail in the wake of the COVID-19 pandemic. Breyer dissented in a similar Wisconsin case in October. The petitioners had asked the court to require Wisconsin to count mail-in ballots received up to 6 days after Election Day, and the court, with Breyer, Sotomayor, and Kagan dissenting, refused the petitioners' request to extend the deadline. Breyer joined Kagan's dissent in Brnovic v. DNC, a case that upheld Arizona's ban on ballot harvesting and refusal to count out-of-precinct ballots. As the most senior dissenter, Breyer likely assigned the dissenting opinion to Kagan. Retirement. After Democratic victories in the 2020 presidential and Senate elections, progressive activists and Democratic members of Congress called on Breyer to resign so that President Biden could nominate a younger liberal justice. In an August 2021 New York Times interview, Breyer said he wished to retire before his death, and recounted a conversation he had with Justice Antonin Scalia in which Scalia mentioned that he did not want his successor to reverse everything I've done for the last 25 years. Breyer said that Scalia's point will inevitably be in the psychology of his decision to retire. In a September 2021 interview with Fox News's Chris Wallace, Breyer said activists calling for his resignation are entitled to their opinion and I didn't retire because I had decided on balance I wouldn't retire. He said he took several factors into account when deciding his retirement plans, and reiterated that he did not plan to die on the court. On January 26, 2022, news outlets reported Breyer's intention to retire from the court at the end of the 2021-22 term. Breyer confirmed his pending retirement in a White House announcement alongside Biden on January 27. On February 25, Biden announced his nomination of Ketanji Brown Jackson, a former clerk of Breyer and judge of the United States Court of Appeals for the District of Columbia Circuit, to succeed Breyer on the Supreme Court. The U.S. Senate confirmed Jackson by a vote of 53 to 47 on April 7, 2022. Breyer retired on June 30, 2022, effective at 12:00 noon EDT, following the court's final opinions and orders for the term. Breyer's retirement left only one military veteran, Samuel Alito, on the Supreme Court. Judicial philosophy. In general, Breyer's pragmatic approach to the law will tend to make the law more sensible, according to Cass Sunstein, who added that Breyer's attack on originalism is powerful and convincing. Breyer consistently voted in favor of abortion rights, one of the most controversial areas of the Supreme Court's docket. He also defended the court's use of foreign law and international law as persuasive authority in its decisions. Breyer is also recognized as deferential to the interests of law enforcement and to legislative judgments in the court's First Amendment rulings. He demonstrated a consistent pattern of deference to Congress, voting to overturn congressional legislation at a lower rate than any other justice since 1994. Breyer's extensive experience in administrative law is accompanied by his staunch defense of the federal sentencing guidelines. He rejects the strict interpretation of the Sixth Amendment espoused by Justice Scalia that all facts necessary to criminal punishment must be submitted to a jury and proved beyond a reasonable doubt. In many other areas on the court, too, Breyer's pragmatism was considered the intellectual counterweight to Scalia's textualist philosophy. In describing his interpretive philosophy, Breyer has sometimes noted his use of 6 interpretive tools: text, history, tradition, precedent, the purpose of a statute, and the consequences of competing interpretations. He has noted that only the last 2 differentiate him from textualists such as Scalia. Breyer argues that these sources are necessary, however, and in the former case, can in fact provide greater objectivity in legal interpretation than looking merely at what is often ambiguous statutory text. With the latter, Breyer argues that considering the impact of legal interpretations is a further way of ensuring consistency with a law's intended purpose. Active liberty/I. None. Other books. In 2010, Breyer published a second book, Making Our Democracy Work, A Judge's View. In it, he argues that judges have 6 tools they can use to determine a legal provision's proper meaning: its text, its historical context, precedent, tradition, its purpose, and the consequences of potential interpretations. Textualists, like Scalia, only feel comfortable using the first 4 of these tools, while pragmatists, like Breyer, believe that purpose and consequences are particularly important interpretative tools. Breyer cites several watershed moments in Supreme Court history to show why the consequences of a particular ruling should always be in a judge's mind. He notes that President Jackson ignored the court's ruling in Worcester v. Georgia, which led to the Trail of Tears and severely weakened the court's authority. He also cites the Dred Scott decision, an important precursor to the American Civil War. When the court ignores the consequences of its decisions, Breyer argues, it can lead to devastating and destabilizing outcomes. In 2015, Breyer released a third book, The Court and the World, American Law and the New Global Realities, examining the interplay between U.S. and international law and how the realities of a globalized world need to be considered in U.S. cases. Other views. In an interview on Fox News Sunday on December 12, 2010, Breyer said that based on the values and the historical record, the Founding Fathers of the United States never intended guns to go unregulated, and that history supports his and the other dissenters' views in District of Columbia v. Heller. He summarized, "We're acting as judges. If we're going to decide everything on the basis of history, by the way, what is the scope of the right to keep and bear arms? Machine guns? Torpedoes? Handguns? Are you a sportsman? Do you like to shoot pistols at targets? Well, get on the subway and go to Maryland. There is no problem, I don't think, for anyone who really wants to have a gun." In the wake of the controversy over Justice Samuel Alito's reaction to President Barack Obama's criticism of the court's Citizens United v. FEC ruling in his 2010 State of the Union address, Breyer said he would continue to attend the address. "I think it's very important for us to show up at that State of the Union, because people today are more and more visual. What see in front of them at the State of the Union is that federal government. And I would like them to see the judges too, because federal judges are also a part of that government." Honors. Breyer was elected to the American Philosophical Society in 2004. In 2007, Breyer was honored with the Distinguished Eagle Scout Award by the Boy Scouts of America. In 2018, he was named to chair of the Pritzker Architecture Prize jury, succeeding previous chair Glenn Murcutt. In popular culture, Breyer has appeared as a guest on Stephen Colbert's TV show. On The Late Show in September 2021, he discussed the Texas Heartbeat Act and his reluctance to retire. Breyer appeared on Fareed Zakaria GPS on CNN in September 2021, where he was questioned on when he planned to retire. He promoted his book The Authority of the Court and the Peril of Politics. Publications: Breyer, Stephen G., McAvoy, Paul W. Energy Regulation by the Federal Power Commission. Washington, D.C., Brookings Institution. ISBN 9780815710769. OCLC 866410. Breyer, Stephen G., Stewart, Richard B. Administrative Law and Regulatory Policy. New York, Little, Brown and Company. Breyer, Stephen. The Federal Sentencing Guidelines and Key Compromises upon which they rest. Hofstra Law Review. 17, 150. Archived from the original on October 5, 2017. Breyer, Stephen G. Breaking the Vicious Cycle, Toward Effective Risk Regulation. Cambridge, MA, Harvard University Press. ISBN 9780674081147. OCLC 2468866908. Breyer, Stephen. Active Liberty, Interpreting Our Democratic Constitution. New York, Vintage Books. ISBN 0-307-27494-2. Breyer, Stephen G., Stewart, Richard B., Sunstein, Cass R., Vermeule, Adrian. Administrative Law and Regulatory Policy, Problems, Text, and Cases. Boston, Ma, Aspen Publishers. ISBN 978-0735556065. Breyer, Stephen. Making Our Democracy Work, A Judge's View. New York, A. A. Knopf. ISBN 9780307269911. OCLC 8138971225. Breyer, Stephen. The Court and the World, American Law and the New Global Realities. New York, Penguin Random House. ISBN 9781101912072. OCLC 9520263314. Breyer, Stephen G., Bessler, John D. Against the Death Penalty. Washington, D.C., Brookings Institution. ISBN 9780815728900. OCLC 9486699357. Breyer, Stephen G. Breaking the Promise of Brown, The Resegregation of America's Schools. Washington, D.C., Brookings Institution Press. ISBN 9780815731665. OCLC 119-777-3870. Breyer, Stephen. The Authority of the Court and the Peril of Politics. Cambridge, Ma, Harvard University Press. ISBN 9780674269361. OCLC 124-662-4044.